Today we're talking about maybe the most powerful idea in any democracy, judicial review. I mean, think about it. It's the power that lets a court with no army, no police force, look a powerful government right in the eye and say, nope, you can't do that. So how on earth does that actually work? Let's dive in.
Here's our roadmap for today. First, we'll define this amazing power to say no. Then, we're going to jump back in time to its surprising American origin story. After that, we'll break down its three main jobs as a guardian of democracy, see how India specifically built it into its own constitution, and finally, we'll unpack a really powerful legal idea called the basic structure doctrine. All right, first up, the power to say no. This is the big one. How can a small group of judges, people with basically just gavels and robes, tell an entire parliament or a president that they've gone too far? That's the fundamental question we're answering here.
Let's start with a really crucial question. We expect the government to protect us from harm, but who protects us from the government? When a law gets passed that feels like it crosses a line, what's our last line of defense?
Well, the answer is this principle called judicial review. Think of it like a constitutional reality check. It gives courts the authority to put any new law, any government action, under a microscope and hold it up against the nation's ultimate rulebook, the Constitution. And if that law doesn't square with the Constitution, the court has the power to say, this is void. It doesn't count.
What this really all boils down to is that the Constitution is the boss, period. Judicial review is the tool that makes sure no law, no politician, no government department can ever become more powerful than the Constitution itself. It's the ultimate trump card that keeps the whole system in balance. So where did this game-changing idea even come from? It's not like it was written in stone from the beginning of time. For that, we've got to dig into its American origin story, which, believe it or not, all goes back to one single court case that completely reshaped modern democracy.
Okay, picture this. It's 1803. The case is Marbury versus Madison. And the U.S. Chief Justice, a guy named John Marshall, drops a bombshell. He puts forward this simple but totally revolutionary idea. The Constitution isn't just another law in the books. No, it is superior to all the other ordinary laws. And that one thought, well, that's the seed that grew into everything we're talking about today.
Marshall's logic was beautiful, and it rests on three main pillars. First, he says, the Constitution is the supreme law of the land. Got it. Second, it's the specific job of the courts to interpret what that supreme law means. Okay, makes sense. And that leads to the powerful conclusion, pillar number 3, if a law conflicts with that supreme law, it has to be struck down. Simple, elegant, and it completely changed the balance of power.
Okay, so we've got the origin story. We know where it came from. But what does judicial review actually do? Day in and day out. In this next section, let's break down its three main jobs as the guardian of the Constitution.
You can kind of think of these three roles as a chain reaction. It all starts with being the guardian of the Constitution. Because it's the guardian, it can then be the protector of our fundamental rights. And when you put those two together, you get its third role, being a major check on government power. Let's look at each one.
So first up, the guardian. This is all about making sure every part of the government, the president, the parliament, everyone, is playing by the rules laid out in the Constitution. It also means protecting the very soul of the Constitution, what's called its basic structure, from being changed so much that it becomes unrecognizable. And trust me, that idea becomes hugely important in a bit.
Second, and this is where it gets really personal for all of us, it's the protector of our fundamental rights. If a government passes a law that messes with your freedom of speech or your right to equality or any other core right, judicial review is the mechanism that allows the courts to step in and say, hold on, that's not okay. It's the legal shield for the citizen. And third, it's a check on power. This is all about preventing any one part of the government from getting too big for its britches. It acts as a brake on random, arbitrary laws, it's a leash on the abuse of authority, and it's a stop sign for unconstitutional policies before they can do any real damage. So we've got the American origin, and we know its main jobs. Now let's see how this incredible idea was adopted and then intentionally forged into a constitutional shield in another one of the world's biggest democracies, India.
Now, this is a really key difference. See, in the US, judicial review was kind of invented by a court case. But in India, it was a deliberate choice from day one. The people who wrote the Indian Constitution, they knew that if they wanted to protect a federal system with power shared between the center and the states and a whole list of fundamental rights, the courts had to have this power. It wasn't an add-on, it was essential to the whole design.
And you can literally see this power woven right into the legal text through specific articles. Article 13 is the big one. It pretty much explicitly gives courts the power to scrap any law that violates fundamental rights. Then you've got Articles 32 and 226, which are like a direct hotline for any citizen to go straight to the highest courts and say, hey, my rights are being violated. The power isn't just hinted at, it's spelled out loud and clear.
And that brings us to our final section, and to a legal idea that makes India's version of judicial review one of the most powerful on the entire planet, the basic structure doctrine. This is all about protecting the very soul of the Constitution.
This doctrine didn't just appear out of nowhere. It came out of a decades-long legal tug-of-war between India's parliament and its Supreme Court. Way back in 1951, the court said, yep, parliament can amend fundamental rights. Then, 16 years later, in 1967, it did a complete 180 and said, nope, parliament can't touch them. This created a huge constitutional standoff that finally boiled over in a legendary 1973 case called Keshavandananda Bharti.
The court was in a tough spot. The Golaknath decision had basically built a brick wall, saying Parliament couldn't make any changes at all. So the Keshavananda Bharti case found this brilliant middle ground. The court's decision was basically this: look, Parliament, you can amend the Constitution, but, and this is a huge but, you cannot use that power to destroy its core identity, what the court called its basic structure.
So what is this basic structure doctrine? It's the principle that certain core features of the Constitution are sacred. They're non-negotiable. Things like democracy, the rule of law, federalism, secularism, these are all considered part of that basic structure, and Parliament simply cannot amend them out of existence. This created the ultimate constitutional shield, protecting the document's very soul from the politics of the day.
Okay, so let's boil it all down. What are the big takeaways here? At its heart, judicial review does three absolutely critical things. It makes sure the Constitution stays on top as the supreme law. It acts as a personal shield for our most fundamental rights. And it puts important limits on government power so that nobody is above the law. And that leaves us with the big, central debate that's always swirled around this topic. Is judicial review the ultimate safeguard for democracy, the thing that protects it from its own worst impulses? Or is it a challenge to the will of the people, where unelected judges can overrule the decisions made by the folks we actually vote for? It's a tough one, and it's definitely something worth thinking about.